Greetings to all. Today we are going to discuss our chapter Public Policy, and in this chapter this is part 3 of the program Role of Executive with special reference to bureaucracy, legislature, judiciary and non-government organization. Today's lecture will be divided in these parts. The first is introduction, then judiciary as an organ of government, then functions of judiciary, importance and role of judiciary, judicial activism, then methods of judicial activism, judicial review. After judiciary we will go for non-government organization. So, importance and role of NGOs and then special reference to Rajasthan. So, we start with the first point, that is introduction. The judiciary is the third important organ of government and may be said to be the touchstone of the merits and quality of a political system. A country may have a very good legislature and an excellent executive, but if it does not have an efficient and impartial judiciary, its constitution is not worth much. Protection against arbitrary rule is a condition which every citizen expects from a civilized government. To provide for him, a properly constituted judiciary is one of the best means by which this condition can be secured. The judiciary is the main pillar of democracy. Lord Bryce says that there is no better test of excellence of a government than the efficiency of its judicial system. So, we see that judiciary is the most important organ of the government for protecting the constitution and rights of the individuals. Now, we go for judiciary as an organ of government. The judiciary is the third branch of government along with the legislature and the executive. The term judiciary is used to designate those officers of the government whose function is to apply the existing law to individual cases. The laws are the basis for bringing order in society by means of judiciary. The judicial process helps the process of legitimacy of the state. The judiciary is the rule adjudication agency of political system. The judiciary consists of the magistrates and judges charged with the function of the administration of justice. Now we come to the functions of judiciary. As we know, the judiciary does the administration of justice, but it performs many functions. The first one, it renders justice to the people. The second one is it interprets laws. The third one, it protects the rights of the citizens. Then it creates law by its own judgments. Then it safeguards the constitution, and the constitution is safeguarded by the power of judicial review, which we will discuss after. Then it protects the federation, because the federal governments have distribution of power between center and the states, and if there is any conflict, then this judiciary, the high courts, the Supreme Court, they decide those conflicts between center and its units. Then next, it advises the government. Sometimes government needs advice on some critical and crucial matters, and at that time judiciary plays an important role as advisory function. Now, it acts as court of records, because judiciary has long decisions with it, and they act as code of records. They keep the records, and whenever the same case comes, it takes example of those records. And the last one is that it punishes for contempt of court. So, judiciary plays very important role and its functions are manifold. Now we come to the importance of judiciary. The judiciary is the guardian of the rights of the citizens, protecting these rights from the government or private encroachment. Every citizen looks to the judiciary to protect his rights. It is the courts which act and serve like watchtowers to guard the liberty and fundamental rights of citizens, and also as laboratories for testing the validity of legislative and executive functions. The judiciary is one of the most vital branches of government. Its functioning is unquestionably utmost concern to the ordinary citizen. Sedgwick says the importance of judiciary in political construction is rather profound than prominent. In determining a nation's rank in political civilization, no test is more decisive than the degree in which justice as defined by the laws actually realized in its judicial administration. So, we see that judiciary plays a very important role and the importance of judiciary cannot be denied. Now, we come to the role of judiciary. The judicature as a political institution plays the greater role in policy formation in any democratic country. The judiciary in India plays a constructive role in shaping and influencing public policies in two ways. And these two ways are by its power of judicial review and judicial decisions. The Constitution entitles the Supreme Court and the High Courts at the state levels to exercise a judicial review of legislation. Through the power of judicial review, the courts determine the constitutionality of legislative and administrative actions. Such actions which are found to be in conflict with the constitutional provisions, courts can declare them null and void. By this, they are not only specifying the government's limits with regard to certain actions, but also saying what it must do for the public interest. In all democratic countries, judiciary by virtue of its constitutional status plays a significant role in the policy making process. Courts are approached to interpret and decide the meaning of legislative provision that are often vaguely stated and contain conflicting interpretations. Supreme Court on 7th December 2015 refused to entertain a PIL plea for directing Parliament to enact a uniform civil code. Thus, the courts generally speaking do not interfere with the policy matters of the legislature or executive under the policy is either against the constitution or some statute or is actuated by malafides. For instance, the Supreme Court refused to entertain a PIL plea to scrap the union government policy decision of the demonetization of high currency notes of rupees 500 and rupees 1000 in November 2016. Any judge confronted with a choice between two or more interpretations and applications of a legislative act, executive order or constitutional provision must choose from among them because the decision has to be given or the controversy must be ended. And when the judges does so, his or her interpretation becomes policy for the specific litigants. When a court accepts one interpretation or a decision is accepted by other courts, the court has made a policy for all jurisdiction in which that view prevails. The judiciary in democratic system has played a major role in the formation of social and economic policies. Much of the law relating to such matters as equal protection of law, property ownership, corporations, employer-employee relationships, and the position of women in society has been developed and applied by the courts in the shape of common law. Famous author Anderson observes, not only are the courts getting involved, but they are playing a more positive role in policy formation, specifying not only what governments cannot do, but also what it must do to meet legal or constitutional obligations. So, in democratic governments, judiciary has played a very important role in policy formation with its decisions and with its guidelines to the litigants, and these guidelines play a very important role in policy formation in various areas. Now we come to judicial activism. The term judicial activism denotes the judiciary's proactive involvement in defending citizens' rights. It is a judicial approach where judges interpret the law broadly and sometimes go beyond the traditional role of interpreting the law to shape social, economic or political policies. In other words, it is a judicial philosophy where judges use their powers to advance specific values or objectives rather than simply applying the laws to the facts of a case. Judicial activism can take many forms, such as overturning laws or policies deemed unconstitutional, interpreting laws in a way that expands individual rights, or issuing rulings that mandate specific actions by government or private entities. A recent example of landmark judgment that demonstrate the role of judicial activism in protecting the rights of citizens is Unikrishnan versus State of Andhra Pradesh case. The Supreme Court declared that every child in India has fundamental right to education. It directed the government to provide free and compulsory education to all children aged 6 to 14 years. So, this type of landmark judgments are always given by the court as a case of judicial activism. Although this case of Unikrishnan versus State of Andhra Pradesh, the children were given the right to education from the age 6 to 14. Here I would like to add that this right is given in the directive principles of state policy, that the constitution gives advice or direction in these directive principles to the government that every child between 6 to 14 years should be given free education. So, in this case, the Supreme Court has directed the policy makers to implement this right, this directive, and this is in the form of judicial activism. Now we come to the methods of judicial activism, that how the judiciary actively plays the role in policy making or in making of public policy. The first method is the public interest litigation, of which we have seen some examples. So, public interest litigation is a type of litigation that allows citizens to approach the courts to seek redressal of public grievance. PIL is a method of judicial activism that has been widely used in India to address issues of public concern such as corruption, pollution and human rights violations. The second method of judicial activism is interpretation of the Constitution. Through this method, Courts protect the fundamental rights of citizens and promote social justice. Next is the striking down unconstitutional laws, and the next method of judicial activism is expanding the scope of existing laws. Next, we come to a very important point, that is judicial review. This power of judicial review is very important in the hands of court, because this concept of judicial review gives the power to the courts to declare any law unconstitutional if it is against the will of the Constitution or the basic structure of the Constitution. The concept of judicial review originated in the United States of America, and I remember that in the famous case of Marbury versus Madison in 1803, Justice Marshall originated this power of judicial review by his decision. If an act violates the provision of the Constitution which can be declared or held as unconstitutional, or ultra vires, which can be declared or held. In federal constitutions, the judiciary is considered as the guardian of the Constitution, which means the judiciary has the power to interpret the Constitution, which is also an important part of judicial review. In this way, the judiciary has the duty of implementing the constitutional safeguards that protect individual rights. Since independence in India, there have been a number of cases where the Supreme Court has enjoyed the power of judicial review and has openly declared an act as illegal or void. It has also interpreted the provisions of the Constitution. To cite a few examples, A.K. Gopalan versus State of Madras case 1950, then Golaknath versus State of Punjab case 1967, Vishakha versus State of Rajasthan 1997. So, these are some of the example cases which give us example of judicial review. The Golaknath case has been a very important case for the amendment of the fundamental rights and basic structure of the Constitution. The courts decide on specific issues. They may not take the initiative. Here it is very important to note that the courts cannot take the initiative of judicial review. The courts can take this power only when some litigant comes to the court and complains about it. So, the lawsuits are placed before the courts in specific and particularized form. The demand made by the litigants and the rules of the judicial process determine the manner in which the problem is presented to the court. A person seeking to invoke the power of the courts must show direct legal injury and must have exhausted all administrative remedies before a judge will listen to the case. The judge must take that particular set of facts and make a decision that will resolve the immediate problem. If the decision is accepted by other judges, the judge has made a policy for all jurisdictions in which that view prevails. For instance, in order to protect women against gender discrimination and social exploitation, the High Court in Himachal Pradesh said that women belonging to the tribal areas of the state will inherit property under Hindu Succession Act 1956 and not as per customs and usages. In the case of India, the relative importance of the Supreme Court and the High Courts has been increasing. The Indian courts have become increasingly involved in prescribing specific policies regarding public schools, labor conditions or welfare assistance to name a few areas. Thus, the role of the judiciary in responding to administrative actions has been to protect the rights of the citizens against the growing state power. The increasing governmental interference in citizens' lives, the failure of government election on social and economic problems, the willingness of the judiciary to play a more constructive role all tend to ensure a continuation of judicial activism in policy formation. The judiciary is itself a constitutional institution, but it has played a very significant role in policy making in variety of areas. The role of judiciary has traditionally been to provide justice and to interpret the laws and advise the government. But with the changing times, the judiciary has also increased its importance and its role due to judicial activism and the power of judicial review. And the judicial activism has made judiciary as a policy maker or a public policy maker, because they have given many decisions and they are giving their advices to the government, and it is like support to the new policies which come to state as welfare state. So, the judiciary is a very important organ of the government because it protects the constitution, it interprets the constitution, and it guides the policy maker through its decisions. So, with this we come to the non-government organization, the NGOs, and these non-government organizations are also a very important part and very important instrument in policy formation and in the formation of public policy. These NGOs are working in different fields, different areas, and supporting the government policies in different important social, economic, cultural and political areas. Generally, NGOs are non-political organizations and they are non-violent organizations. Through civil society, they work for the betterment of the society. NGOs or non-governmental organizations or voluntary agencies have of late emerged as agencies of social change and instrumental in bringing large-scale sustainable changes at various levels of society. The emergence, development and importance of these organizations constitute a significant and integral aspect of social transformation. NGOs have been generally defined as voluntary, autonomous, non-profit, non-violent associations of individuals or groups of citizens established to address various issues, problems and disadvantages in the society. They are independent of government that aggregate interest and inject them into the policy process. What differentiates the NGOs from the rest is that they are, whether their workers are paid or unpaid, initiated and are governed by the members without external control. So, these non-governmental organizations, they are group of the citizens, of the members of the civil society which work not for their profit but for the service of the society. And these non-profit organizations work autonomously or independently and they support the different government policies and government departments. Now we come to the importance of non-governmental organization. So, these NGOs and the pressure groups are important means of enhancing the effect of public opinion. They communicate more effectively than individual citizens with public officials on implementation of public policies. They serve as links between individual citizens and policy implementers. They help the policy implementers by offering personnel and expertise in the policy implementation issues. The NGO's role is very important. NGOs in India have been trying to sensitize, organize and mobilize people of village, local, community level and various other levels, and also interested groups, particularly the poor, to enable them to pursue self-development, fight for their rights and apply pressure on the government when needed. All these involve a process of education, organization, struggle and reconstruction. NGOs have been quite successful in bringing to the attention of the government to some of the burning problems in respect of development, poverty, unemployment, illiteracy, ill health, disparities, incidence of bonded labor, exploitation of women, children, tribals and weaker sections women's rights, peace and social cohesion and communal harmony, equal opportunity to different social, cultural and ethnic groups to pursue development and contribute to national regenerations. There are some special cases, and one of these cases I would like to quote here, and this is with the reference of Rajasthan. In creating public awareness and holding the government socially accountable, the NGOs have a major role to play. Most innovative approaches to ensure people's access to information have come from the NGOs in developing countries. For instance, in rural Rajasthan, it is almost a household word now that the revolutionary zeal shown by the Mazdoor Kisan Shakti Sangathan, a local NGO, brought about remarkable changes in the field level government operations through awakening of the rural masses. It is through the untiring efforts of this Mazdoor Kisan Shakti Sangathan that the right to information grew into a local movement, and ultimately Rajasthan government on public demand came forward with a new legislation on the right to information. Mazdoor Kisan Shakti Sangathan has been highlighting corruption in government expenditure in field projects. It exposes bribery and alleged payments made to labourers and suppliers of construction material. Information is further cross-checked through a system of public hearing locally called Jan Sunwai, which are held face to face and allow workers to testify personally. In this process, MKSS helps overcome illiteracy and other forms of social backwardness. Here I would like to add that this is only one example. There are many more NGOs working in different fields for the women, for the children, for poverty, for illiteracy and eradicating social evils, and these NGOs are playing a major role in the development. In the field of environment also, there are NGOs working to implement the public policy. Politicians and bureaucrats generally welcome the inputs of interest groups and NGOs because these provide information which helps to identify policy alternative and choices. In addition, powerful interest groups affect the policy implementation process. They will seek to intervene at every stage in the policy implementation chain, basing their strategies on those parts of the chain which seem most open to influence. In spheres like pollution control, land and agriculture policy, and in many other social policy areas, the NGOs affect administration. The cooperation within the implementation process is seen as a way of handling and channeling conflict of interest. For example, the Chandigarh State AIDS Control Society often collaborates with Sehat, an NGO, for the implementation of program against drug abuse and illicit trafficking. So, there are many more examples of NGOs like these working at different states, different cities, and they support the public policy makers in implementing the public policy. More and more public agencies are becoming dependent on the voluntary sector and the NGOs to deliver services, including the implementation of policies which they find either difficult to provide or have not the resources to provide, or which have traditionally been provided by the voluntary sector. A few NGOs are taking a lead in this regard and are working in the areas of social mobilization, awareness, raising environmental protection and income generation. The exercise of influence on the implementation process through the interest groups and NGOs is a feature of Indian public administration. For the ordinary individual interest group is the important channel of communication. The environment of the interest group in the policy implementation suggests that the policy issue are best settled by bargaining during the implementation process. This may be seen as the development of discretionary powers in the hands of the interest groups or NGOs. So, these NGOs play a very important part in the implementation of public policy. These are the times when the states have a large burden of their functions as a welfare state, and they work for the every field, every area of their citizens' lives, and with this increasing work, these NGOs are becoming the lifeline of the government in completing their targets, in completing their programs and policies. In the end, I would like to say that today we have studied the role of judiciary as a public policy maker. We have seen the importance, the role and the ways how judiciary works. The two important functions done by the judiciary which have come with the passage of time as public policy makers is the power of judicial review and judicial activism, and both these have given a new way to the judiciary as a supporter of the public policy, as the implementer of public policy and a guide for the government to form the public policies. And to add to that, the non-government organizations or the NGOs which are non-profit organizations, and they are worked by the civil society persons which work effortlessly and selflessly for these NGOs, and these NGOs help the public policy makers to complete their targets, their policies and their new directions in the field of public welfare. Thank you.